Good morning, everyone. Welcome to mylegaladvocate.com, brought to you by the law firm of Marecki and Medolla. And I'm here this morning with founding partner, Tim Marecki. How are you, Tim?
I'm doing great, Blanca. Good morning, and thank you for having me. How are you?
I am doing very well, and I'm excited because today is a really important topic, and it's the issue of how to document damages after an accident occurs, the do's and the don'ts. And I think there's going to be a lot of questions that a lot of people are going to hear, questions they've asked themselves. And everybody feel free to post questions in the chat as well. But my very first question is once you have an accident and somebody has a slip and fall or some type of injury occurs, should they be immediately documenting the claim?
Yes, Blanca, they should. When you're making a claim for an injury that you sustained that's someone else's fault, the claimant is required to prove by preponderance of the evidence that A, this accident occurred, B, it was someone else's fault, and C, that they were injured because of it. Because we have to affirmatively prove our case, the more ammunition that we have to do that, the better. If we have pictures of the scene, if we have a description of the dangerous condition, if it's a car accident, if we have pictures of both vehicles, if we can identify people that saw what happened and get their names and contact information, that's very important. All that information is going to help your attorney to get you compensated for your case. Now, having said all that, I don't want anyone out there to think just because they don't have pictures or they don't have good documentation of what happened, that does not necessarily mean that we can't help them. We have a lot of different ways to establish what happened. So do what you can to document the incident, but don't worry if you don't have it.
That's excellent. Now, what if I have some degree of liability or responsibility in this accident? How does that change the situation?
Yeah, Blanca, great question. Just because you are partially or even mostly at fault for what happened doesn't mean that you can't recover. Our state has a legal concept and it's called comparative negligence. And what that means is that when you go to court, the jury can actually decide what percentage each party is at fault for the particular accident. So even if something happened is mostly your fault, if there's another party that's partially responsible, you can recover against that party. We've had clients here that have recovered hundreds of thousands of dollars when it was them that was mostly at fault for what happened. Because of comparison, just because you're mostly at fault doesn't mean there's somebody else that shouldn't be at least partially responsible. And that concept works here over and over and over again. So don't think because it's your fault you don't have a claim. You may not, but you very well may.
That is so reassuring, because I know there's a lot of people out there that are making wrongful assumptions just because they think there's a degree of liability on their part, that they don't deserve a lawyer, that they don't deserve a defense. So this is really, really important information today. And going to my next question, what about statements? What do you recommend as far as assuming or admitting degrees of liability at the accident?
Yeah, at the scene of the accident, most likely the law enforcement agency is going to come and they're going to interview the people that were involved, and they're going to make a report. And in my experience, I find that people are very concerned about what the officer is going to put in his report, especially particularly in a car accident. People always want the officer to write up that the other person was at fault, and they're afraid if the officer writes it up as them being at fault. But what most of these people don't know is there's an accident report privilege in Florida. And what that means is that nothing in that officer's accident report is admissible in court. So don't concern yourself too much with what you say, because none of that can be used to prove that you were at fault or not.
That really is very eye-opening as well. Now, what about general obligation in terms of if there's an implication of possible criminal, alcohol or drugs? What's the recommendation there?
Yeah, as far as, I mean, we're not criminal attorneys, but you absolutely have a right to remain silent. You do not have to speak to the police if you don't want to. If you're concerned about drinking or illegal substances in the car or anything else that might be going on, you do not have to answer to questions that the police are asking you.
Is it an admission of guilt to sign the ticket if I get a citation at the scene?
No, absolutely not. Signing the ticket is not an admission of anything. You sign the ticket. It's just an agreement that you'll appear in court to face the charges. We've had several clients that have gotten tickets for car accidents. Actually getting a citation in a car accident, that's going to be something that's admissible in court. So what we do here at our law firm is we take on that responsibility of referring our client to our traffic court attorney, and we get most of those tickets thrown out because we don't want those tickets on the record when we're negotiating your case.
Oh, that's excellent. And what about photographs? Is it a good idea to take photographs at the accident?
Yeah, absolutely. I mean, the more pictures you can have, the better of your vehicle, of the other vehicle, of the surrounding area. The one thing I would say is, don't be obnoxious or loud about it at the scene. Just kind of go about that in a business-like and quiet manner.
That's good advice. And is it my responsibility to identify witnesses at the scene?
Well, I mean, you don't have a responsibility to do anything, but like I was saying before, witnesses are ammunition that is going to help your attorney prove your case. And the more ammunition you could provide that attorney in the form of contact information for the witnesses, photographs, and things of that nature, the better off we will be in being able to prosecute your claim.
And what if insurance representatives ask for a recorded statement from me?
My answer to that question is do not speak to any insurance company, including your own, after an accident before consulting with an attorney.
Okay. I think one of the other problems is that a lot of people think because they can't afford an attorney, they don't deserve an attorney. And just to be really clear, does a person need any form of money to retain your law firm?
Absolutely not, Blanca. Our law firm provides free consultations all day long. I spend most of my day talking to people about their claims and potential cases. And sometimes we're able to take those cases and sometimes we're not. The consultation is always free. We'll spend as much time with you as necessary to determine how we're going to advise you to proceed. And when we do accept your case, you never pay anything out of pocket. We work on a contingency basis, and we only get paid a portion of the recovery if we win for you. Something that people may not know is insurance companies are working hard in Congress and in our state legislature in Florida to make contingency fees illegal. And the reason they want to do this is because most people can't afford attorneys' hourly rates. And if there were not contingency fees, the majority of accident claimants would not be able to have an attorney on their side going up against an insurance company or a big company, and they would lose. The contingency fee is sacred, and we never, ever, ever ask a client for money, ever.
Well, that's because what's the best way to document my physical?
Yeah, a good way to do that is as you're going along, one thing we suggest is journaling. We'd like you to keep track of the doctor's appointments you've attended, the time that you've missed at work as a result of your injury or having to go to the doctor, the time that you've missed with your family, and every way that this injury is affecting your life on a daily basis. If you could write that down as you go, it will be extremely helpful to us in prosecuting your claim. And one of the reasons is a lot of the time we don't get our day in court for years after the accident happened. And that journal is going to help you remember those details. And those details are key. We use those details in court to convince the jury that you're entitled to a financial award. So the more that you can do to keep track of what's been going on with you, the better it's going to be.
And the same with journaling for mental or emotional injuries as well.
Yeah, absolutely. The one thing people should know about mental or emotional injuries is, or mental or emotional damages, I certainly understand the concept of being emotionally hurt as a result of an accident. I understand the concept of being depressed and not being able to do certain things and having this injury, affect the way that you view life and affect your mental health. I get that. In order to recover for those damages, you must see a mental health professional. We cannot legally recover from those damages just based on you saying that you've had mental problems as a result of this. So if that's important to you, if that's really affecting you, and that's a major element of your claim, we suggest that you see a mental health professional and let that person make a diagnosis and a documentation of what's going on with you.
This is seriously good. Episode today on My Legal Advocate, Tim Marecki. Thank you for educating our community. Marecki and Medolla, your personal injury attorneys putting community first. Thank you so much and have a wonderful day.
Thank you very much, Blanca.